Welcome everybody. My name is Jeff Fowler, the president of the Apartment Owners Association, and it is great to have you with us today. We're going to be talking about security deposits, and there are a lot of mistakes that are made, and there's some basic information that we can share here and help you navigate through that. So we're excited about that. And AOA, our goal is to help you become the most successful rental property owner in the state. And so we're dedicated to that and providing this kind of content, having the advisors where you can call in, the articles in the magazine, all those things go together to contribute to helping you and putting the right tools in your hands so that you can do that. And so we're excited today to have a renowned speaker with us. But before we get into that, there's a few other things that are coming up. Even at 1 o'clock today, we have another live stream, and it's going to be about 1031 exchanges into DSTs and how you can take exchange out of the state into a different state. And anyway, so if you haven't heard anything about that, you'll want to catch that for the first time at 1 o'clock. Many of you have already heard about it. And then on October 4th, we're going to cover how much can I raise the rent in Los Angeles, in LA City, LA County. And then October 10th, we're going to be covering rent control in Inglewood. And anyway, there are lots of different seminars and things coming up. And of course, there's the $1 Million Trade Show. That's coming up on October 19th. And we're really looking forward to seeing you there. We have definitely, there's going to be over 150 booths at the show. So you'll meet all kinds of vendors that are specifically trying to reach you, specifically trying to help rental property owners. And so you'll want to visit all the different booths, and many of them have prizes that they're going to raffle off. And of course, we will have prizes as well at every single seminar. We're going to be giving away a cruise. But more than that, and definitely more than that, 6-month free membership if you've never been a member of AOA before. So register online, go to the AOAUSA.com website, and you can register. And in the registration, you can see the full agenda, all the different topics, all the different speakers that will be speaking. There's over 20 different seminars in one day. And we'll cover how to bulletproof your assets, setting up that trust. If you haven't done that yet, that's something that you need to do. And so it really is, it's a perfect opportunity to invest into yourself and to your business. And then for those of you that aren't in the LA area, I know we had a couple seminars in Northern California just recently, but San Diego, we're going to have a double header, and we're going to cover that trust, as well as have a landlord-tenant attorney speaking on just the creating a lease, that whole process, specifically in San Diego. So that's a doubleheader in San Diego that's going to be on October 27th. So don't miss that one. And again, there's all kinds of seminars and things coming up. So you'll want to just look at the AOAUSA.com website at the seminars, and you'll see what all's in there. All right, so if you have questions, I see there's a couple questions already. If you could hold your questions, our speaker may answer your question. And so just hold your questions a little bit. And then if you're watching on AOAUSA.com, there is the blue help button at the bottom right side, and you can put your question in there. On YouTube, Facebook, you know what to do. And anyway, so here, I guess we're going to get into it. Our speaker today, he's done over 250,000 evictions, 45 years in the business, and he's got 24 attorneys on his staff at this point. He's grown significantly over these last few years just with the influx of evictions, and just it's been just crazy for the entire industry for sure, and he's trying to keep pace with everything. He is the columnist for the AOA Legal Q&A article that's done, and so many of you see that in the magazine. Here's last month's issue, and he wrote about the Section 8. I don't even know if he remembers what he wrote about, but he wrote about Section 8, so you can check that out. And every month he'll cover different questions that that you guys email in, or that he just sees happen, questions that are being asked frequently. And so that's always a great article. If you're in Orange County, he writes an article specifically for Orange County. If you're in San Diego, we have another attorney that writes there. If you're up in Northern California, and yet another attorney that is practicing locally up there. And anyway, so that's a great article. So I just want to encourage you to look at that every single month. And it's just one little habit, one little thing that you can be doing to stay in the know. And you'll see that there's a whole lot of different things in there. Anyway, at the trade show, he's going to be speaking at 3 o'clock. So definitely clear your schedule, October 19th. And we have seminars going all day, but he's going to be speaking at 3 o'clock, navigating new eviction requirements in LA and the Southland. So he'll be covering some of LA County, what would impact Orange County, just that whole area. And he is the founder and president of the law office of Dennis P. Block and Associates. And so it's my pleasure to introduce to today Dennis Block.
How are you, sir? Mr. Jeff, how are you? You got your mic off? There we go.
There we go. Now we're on.
Now you're on. Now I can hear you.
It's good to see you today, Dennis.
Always good that you put these events on, and I'm always happy to do them for you. This is, ladies and gentlemen, Jeff says, hey, we need you for a seminar. I go, okay, I'll do the seminar. He goes, this is what I want you to talk about. I go, really? Security deposits? So then, of course, I'm thinking, you know what? Great idea, Jeff. I actually took a look at the code the last couple of days and found some little parts that I wasn't even aware of. So we'll see what occurs with that. The issue with security deposits are that landlords tend to get sued in small claims court all the time. They didn't give it back in time. They didn't give the right amount. And quite frankly, if you go to small claims court, you're going to lose. And the reason why you're going to lose is because you're a landlord, and everybody who's a landlord loses in small claims court. You always have a right to appeal in small claims courts to get your case heard by a new judge. But I'm going to give you some tips and tricks of how to avoid getting sued with regard to security deposits. And I don't know why it is, Jeff, but so many people always know if I'm leasing out a unit, I'm going to take a security deposit. Everybody knows that. It's like Pavlov's dog. Leasing it out, got to get that security deposit. But it kind of shocks me that people don't know what to do with the security deposit once the tenant's leaving. Everybody knows to take it, but they have no idea. So how is it possible if they know to take it, but they don't know what to do with it at the end of the tenancy? So let's talk about that and exactly what you can and can't do with a security deposit, how much you can take, how to avoid getting sued. And it's just an interesting topic. And of course, it affects every income property owner that takes on a rental, is going to take a security deposit. So quite frankly, you just got to know about it. So first thing I want to talk about is how much can you take? So if I'm going to tell you how much it's going to take, let's share the screen here. Let's see how good this one works out today. And I think that will share the screen. Perfect. So this is what the amount you're allowed to take for a security deposit. If you're residential, we're talking, if it's a residential property and it's unfurnished, you're entitled to 2 months rent. So if the rent was $1,000 a month, you'd be entitled to get $1,000 first month's rent and also a 2-month security for $2,000. So that would be a total of $3,000 for move-in. If you have a furnished unit, and I know most people don't, but if you did, then you're entitled to a 3-month security. So in that example that I just gave, you'd have the first month's rent, which would be $1,000, a $3,000 security would be a total of $4,000. Now, here's one that I didn't know, that if you're renting to somebody as an active military person, you can only get a maximum of 1 month for an unfurnished unit and 2 months for a furnished unit. I never knew that, but that is the law. And I bet not many people knew that. So if you are renting to somebody who's in the military and it's unfurnished, don't charge more than 1 month's rent on that. For commercial, if any of our listeners own commercial units, there is no limitation. You can get whatever you want for a security deposit, as much as you like on that. Now, people always get a security deposit, and then I always hear them say, you know, I'm going to also get a last month's rent deposit. I'm going to get a pet deposit. That's all illegal. You can't get anything other than a security. All deposits are considered a security deposit. So it doesn't matter what you called it. And quite frankly, it's not to your advantage to call it a pet deposit, and it's not to your advantage to call it a last month's rent, for the following reason. If you took $1,000 security deposit and an extra $500 for the pet deposit, what happens in 2 months if he gets rid of the pet or the pet dies? Does that mean you got to give the money back? Well, kind of. I don't need the deposit anymore. I don't have a dog, so give me the money back. But you see, if you got yourself a $1,500 security deposit, then in that situation, you would be able to keep it, whether he has the dog or not. Now, the same thing is true for a last month's rent. So let's pretend the rent's $1,500. You got yourself a $1,500 security deposit, and you got yourself a $1,500 last month's rent. Well, that still equals $3,000. So it's a $3,000 security or a $1,500 security and a $1,500 last month's rent. What's the difference? Well, here's the difference. If I come to you on October 1st and I say, hey, here's my 30-day notice, I'm moving, then I don't have to pay you rent because you called it, Mr. Landlord, a last month's rent deposit. So since you called it a last month's rent, that's my last month. And then on October 31st, on Halloween, you go over there saying, okay, give me the key. And the guy says, you know, I'm not moving. You see, I wanted to make you wait 30 days because I had no money to pay you and I had no reason to move because I can't move. So I figured I would delay this case by 30 days. So as you can see, there's no advantage to a landlord calling it a last month's rent or a pet deposit. There's no reason to do that because it's not to your advantage. So again, if you have an unfurnished unit and the rent's $1,500, get yourself a $3,000 security deposit. In this day and age, you want to get the maximum security deposit that you can. And again, if it is the unusual furnished unit, then you'd be entitled to get a 3-month security. Okay, again, we're not going to call it a pet deposit or a last month's rent. We're going to call it one thing, pretty simple, call it a security deposit. Now, can you also, in addition to getting the first month's rent and a 2-month security, can you get something called advanced rent payments? Can you do that? I bet you Jeff doesn't even know. But believe it or not, you can. I'm trying to make this dramatic. You can get an advanced rent payment, but there's a crazy law. And that is that the advanced rent payment has to be at least a 6-month lease, and you have to get at least a 6-month advanced rent payment. So if I wanted to get a 2-month security, I could ask for the first, and it's a year's lease, I could ask for 1 year's in advance. That would be permissible. Or if it was a 6-month lease, I could ask for the full 6 months, pay me it all. Plus the of course, the first or the security deposit plus the advanced rent payment. But can you do, let's say, a 3-month advanced rent payment? And the answer is no. So there's a really kind of a quirk in the law. Let me get rid of this. Let me stop sharing so you get to see my beautiful face. There's a quirk in the law that states that you can't get it for less than 6 months. So we have many clients. In fact, I just had one the other day where they get 6 months rent in advance, and the rent per month was rent for 6 months was $50,000, and they got that in advance, and that's what the terms of the lease were. They were going into the second payment period, which was 6 months later. And of course, yesterday we took this case in, the tenant didn't pay the second payment of $50,000. So on that basis, we're serving a 3-day notice and proceeding forward with an eviction. And if anybody knows anything about the threshold that Los Angeles covers, trust me, this one is above the threshold at $50,000. So it is permissible. And sometimes you're dealing with somebody that has really just terrible credit. And sometimes they'll just come up and they'll offer you, say, hey, I'll give you 6 months rent in advance, or I'll give you 1 year's worth in advance. Well, that's permissible. Do a 6 month or a 1 year lease and get it all up front. And then just put on your calendar that after the first year, just put on your calendar that you're going to call me, because you know he's not going to pay you anything after that, presumably, but we'll find out together. Okay, so that's what you can get when the tenant moves in. But what about when the tenant moves out? What are you allowed to deduct for? So let me pull that one up here. See if I can do this without much trouble. And these are the deductions that you are allowed. Hit it there. Little screen sharing here. I'm getting good at this, Jeff. Okay. So what can you deduct for? Okay. You're allowed to deduct for reasonable cleaning charges. You're allowed to deduct for any unusual wear and tear to the property, unusual wear and tear. And you're allowed to deduct for any rent owed or future rent owed. Let me see if I can make this full screen. Let me see if I can do that. Kind of close. Almost got it in there. Yeah, I got it. So any rent owed, any unusual wear and tear, reasonable cleaning charges, and defaults in any future payments in rent. So let's go over each one of those. Obviously, if he owes you rent, you're allowed to deduct it from the security deposit upon move out. So the tricky part is, well, you know how much he owes you. That's easy. You know, you didn't pay for the last 3 months. I'm going to deduct that from the security deposit. And this is an itemization that you're doing. And when I say return the security deposit, you're not necessarily returning any money. What you're doing is you're itemizing the security deposit. And if there's money to be returned, then there's money to be returned. If there's no money to be returned, it might even show that there's a balance owed to landlord. Okay, so what are you allowed to deduct? Well, any rent owed, but of course, we have to think about that. What if the rent that's owed, and you were talking about a municipality, something off the top of my head. Oh, I know, we'll talk about Los Angeles. What if the tenant owed you rent prior to February 1st of 2023? That's COVID time. Are you allowed to deduct that from the security deposit? Because it's rent owed. He owes me rent for, let's say, December 2022 and January 2023. Am I allowed to deduct that? He's moving out now, for God's sakes. Am I allowed to deduct that? Well, the answer is no. You can't use that as a deduction, because under the crazy rules for the city of Los Angeles, that rent is not due until February 1st of 2024. So if it's not due, then how do you say it's owed to me now and I'm going to deduct it? Now, I know what I would do. I would deduct it anyway, but I'm not giving that as legal advice. I'm just telling you what I would do. But technically, legally speaking, you're not allowed to deduct COVID rent, which is not due at this point in time. Any rent owed from, in this, we're talking the city of Los Angeles, from March of 2020 through September of 2021, that's due right now. As of August 1st, it was due, and we can actually evict for that right now. ladies and gentlemen. So if you want to call my office, if any rent is due for the period in Los Angeles, once again, that's March of 2020 through September of 2021, we can start an eviction on that. We have to serve a 15-day notice to pay rent or quit, but we can ask for it now. But in the example that I'm giving, if the tenant is moving, can I deduct for that? Well, certainly you can deduct for any rent owed from February 2023 currently, but any rent prior to that, then technically it's not due. That would be the rent due from October of 2021 through January of 2023. Technically that rent's not due until February 1st of 2024. So technically you can't deduct it, but I know what I would do. But notwithstanding that, I'm telling you what the law is. You are also allowed to deduct for any unusual wear and tear. Any unusual wear and tear. Well, what's that? What's unusual wear and tear? Jeff told me that I could go about 2 or 3 hours on the definition of what's unusual wear and tear. And really, there is no clear examples that I can give you. For example, if the tenant gave you a 30-day notice, and at the end of the 30 days, you meet him at the front door. He hands you the keys, shakes your hand. It's been a nice time. Love you, Mr. Landlord. And he walks out just when he was supposed to, and he even paid for his last month's rent. So right now you have to account for the security deposit. And what if you open the door and the carpeting is ripped to shreds, ladies and gentlemen, ripped to shreds? Are you allowed to deduct the carpeting that was literally ripped up every single place in that unit? And the answer is no. But isn't that wear and tear? No. Well, why isn't it wear and tear? It's not wear and tear because, ladies and gentlemen, the carpeting was 30 years old. You see, that's the point. If the carpeting was 3 months old, 1 year old, and it's ripped to shreds, that would be unusual wear and tear. But what if the carpeting's 30? So when you're thinking about unusual wear and tear, you have to think to yourself, how old is that carpet? Okay. Oh, I walked in and a door was off the hinges. Yeah, but you know what? A door can fall off the hinges using it after so many years, 30, 40 years. There's not going to be too much unusual wear and tear for a tenant who's been in your unit for 20 years. There's just not going to be. Everything's going to wear out. Come on, ladies and gentlemen. And besides, you know you're going to fix up the unit anyway. But if the guy's been there only 2 years and the carpeting is ripped to shreds, and magically you see that there's doors off the hinges, the chandelier's been ripped down, there's just wires hanging where the smoke detectors were, that you can determine is unusual wear and tear for a unit. So you basically have to just go in there and think, hey, normally when a tenant leaves, is this the type of condition that the unit is typically in? And the answer is, well, if the answer is yes, then you're going to be able, you're not going to be able to deduct for these items because it's not unusual wear and tear. Well, but what about the guy who puts in all these nail holes into my wall? You know, nail holes. I had to spackle that up and I had to paint over that. Isn't that unusual wear and tear? Well, let me ask you something, ladies and gentlemen. Who doesn't put picture frames and nail them into a wall? Who doesn't hang a TV? Is that really unusual? Look around your house. If you're sitting home right now, you got pictures up on the wall. Is that unusual wear and tear? So the answer is probably not. Now, if the guy had 4,000 nails in the wall, I agree with you. If you see gaping holes in the wall, I agree with you. That's unusual wear and tear. But the trick is be conservative, because we all know what's going to happen when you go to small claims court. You're going to lose because there's not a judge there or a commissioner that's going to hear your case that's not going to say you're the bad guy. It's just the way it is. You just lose because you're in small claims court. So be conservative when you're trying to figure out what's unusual wear and tear. Think about what other tenants, how they leave the premises when they walk out the door, and determine whether that's truly wear and tear. Now, if you see that there's pieces missing, like on the stovetop, the burners are missing, something to that effect, that's unusual. If you see that the toilet and the sink have been removed, that's pretty unusual. So in that situation, you are allowed to deduct for that. Let's move on to cleaning. Can I deduct for cleaning? Yes. Oh, by the way, can you have a phrase in your contract that it's going to be a $300 non-refundable cleaning charge? And the answer is no. You just call it a security deposit. I've already warned you, so don't even start thinking about that. It's just called a security deposit, and you are allowed to deduct for your actual cleaning charges. Now, if the tenant cleans up the unit himself and it's good, can you still deduct for it? And the answer is you can still do your own cleaning so that it's at a higher level to your standards, and where you sanitize the oven and everything in the unit. So you can charge for that, but it's what it actually costs you to clean that unit. You can't have a set fee. Well, we charge $450 to clean a unit. That is not set. If you hire a company and they charge, well, that's what they charge for cleaning, and it's their set fee, that's okay. But you can't just charge the tenant this deduction. It's what it actually costs you to clean the unit. The last one that we're going to go to is future rent defaults. And you might ask, what's that? Well, if the guy's on a 1-year lease and he leaves after the 3rd month, you can put into your itemization that he's costing you you owe an additional 9 months worth of rent. You left after 3 months. So I'm going to write on my security deposit itemization that if the rent's $1,000 a month and you paid me for the first 3 months, but then you just left, well, you owe me 9 more months worth of rent. So I'm going to write on that, you owe me for future rent $9,000, which is going to be deducted from your security deposit. I would make a note to the tenant, because it is your obligation under law, that you have to use your best efforts to try to re-rent the premises to somebody else. And to the extent that you did rent those premises out, let's pretend in the 6th month, it took you 3 months and you advertised properly and you tried your best efforts, then he owes you 6 months worth of rent. And therefore, the next 6 months, it's not his responsibility. So in that situation, once you get the premises rented, and you should make a note of this on the security deposit itemization, that I'm deducting 9 months now, but if I do rent it out, then I will charge you, I will give you back that additional rent. Now, what if the guy moved out of a 2-bedroom apartment, and I just told you had to use your best efforts to lease it to this new party. But you see, I've got 2-bedroom apartments. So do you have the right to do the one that's been vacant? Or are you duty bound because you have to use your best efforts to re-rent this? And the answer in that situation is no, you don't have to rent out his unit. Rent out the vacant unit. You don't have to rent his first, since you already have one. Get that one rented, because he's still paying you on the second one. Once that one's rented, then you can then try to use your best efforts to rent out his unit. And then once that unit is rented out, then you could return the difference. If for whatever reason you cannot, stop yawning, Jeff. No yawning. I want you to be really on top of your game here. If you can't rent it out, then he's going to be responsible for the full, sorry about that, Jeff, for the full 6 months that he did, and therefore that $9,000 deductible was permissible. Okay. All right. That's what future rents are. Let me stop sharing my screen here, because I think that's the end of screen sharing. Let's go to another point here. There is something called a security deposit initial inspection. Initial inspection. What is that? Well, this only deals with the time that either you gave your tenant a notice to terminate the tenancy, like a 30 or 60-day notice, and you had the right to do so, or more likely your tenant gave you a 30-day notice. Hey, I'm on a month-to-month tenancy. Here's my 30-day notice. Now, do you have to do what they call this initial inspection regarding the security deposit with the tenant? And the answer is no. No, you don't. Only if the tenant requests it. If the tenant requests this, quote, initial inspection for the security deposit, then you are duty bound to do so. The tenant has to ask for this within at least 2 weeks or longer before that termination date. So if he tells you I'm moving on October 1st, he says I'm moving out on October 31st, more than 2 weeks or more, he's got to tell you. So let's pretend by the 15th of October, he's got to tell you, hey, I want that initial security deposit inspection. Well, what does this mean, this initial security deposit inspection? It means that you set a time and a day with the tenant, and you go into the unit with the tenant, and you look around, and you make a list for the tenant as to, well, look at this. I noticed that this cabinet door is ripped off its hinges. I'm going to have to charge for this. And boy, you used to have a really, really nice smoke detector up there. And while I think that gaping hole does allow for some, some antiquity for this place, I'm going to charge you for that smoke detector. And it's interesting. I like the lattice work you did in the window, that you broke the damn window, and I'm going to charge you for that too. So what you're doing, the concept is you do this pre-inspections with the tenant so that the tenant has an opportunity to fix it. And if the tenant has an opportunity to fix it, then you can't obviously deduct it from the tenant. If the tenant asks you, okay, I want that inspection, and he's got to tell you at least 2 weeks before, then you and your tenant are supposed to come to a reasonable time that you guys will meet. So you try to meet with him. If he's unreasonable or you just can't do it, then you need to at least tell him, okay, I'm doing this on Monday at 10 o'clock, and you have to give him at least 48 hours notice, okay? Now, the code doesn't really state, that I could find, what happens if you don't, but you don't want to be the subject of a small claims court justice. So if he asks for it, and only if he asks for it, then go do it. Now, does that mean that everything you spotted is the only thing that you can ultimately put on the security deposit itemization once he leaves? And the answer is no. A lot of times when tenants are moving, they move the couch, and oh my God, look what you did underneath the couch. So you're not going to know that because you're not picking up a couch. You're not moving things around. And once all of his stuff is out, you can see what the little bugger did to your unit. So in that situation, you can certainly deduct more from the security deposit than what you found during the pre-inspection, as I call it, which you're only duty bound to do if, in fact, the tenant asks for it. But if the tenant asks for it, go do it and point it out. And maybe the tenant's going to redo the unit and fix that. You know, I wanted to circle back to the cleaning of the unit. And people say, well, part of the cleaning is that I have to paint. I mean, come on, that's painting. I got to clean. Well, let me tell you something. Cleaning is not painting. Okay, it's not. When you clean your house on Saturdays or whenever you clean it, I'm telling you what you don't do. You don't get out the paint cans. Okay, that's not cleaning. So painting would be under unusual wear and tear. And if the tenant, you walk in and you see that those wonderful children that they had, I mean, just great children, decided that they were going to use, instead of paper for their coloring, they were going to use the walls for their coloring and their crayons. That would be considered unusual wear and tear, and you would have the right to paint and deduct it from that security deposit, okay? But if the guy's been there for 7, 8 years, you know what? You're going to need to paint the unit. I mean, that's just what it is. And you're certainly not going to be considered unusual wear and tear. So again, clearing that up with regard to painting. Painting is not cleaning. Nobody pulls their paint cans out when they're cleaning. If you hire a cleaning service, they don't bring paint cans with them. So it can only be unusual wear and tear. And that's where you got to see the or maybe the tenant, for example, painted a room black. You know, he's of that cult, that Sabbath cult that loves to have everything painted black. Or maybe he's a big Rolling Stone fan. Okay, you're too old to even know what the hell I'm talking about. But so he painted it black, and then you have to go in there and you have to repaint it. Well, that's unusual wear and tear, ladies and gentlemen. You can certainly deduct the painting from that. Okay, so we talked about what you're allowed to deduct for. We talked about how much you can get. We talked about the pre-inspection. And now we're going to tell about how everybody loses in these cases. And that is, you've got to send that itemization within 21 days from when the tenant vacated the unit. 21 days, you have to send that itemization and any money, if you owe money, to the tenant. Okay? And it's from when you knew or reasonably should have known that the tenant vacated. So if the tenant's in the middle of a lease, but he vacates on October 1st, but you still got 9 months to go, you've got 21 days from when you knew he vacated or should have known that he vacated, okay? Or he told you that he vacated. You got 21 days to either personally deliver it to him or to mail it by first-class mail. Can you mail it by certified mail? Of course. But the law requires first-class mail within 21 days of when you knew he vacated. Okay. If you mail it on the 21st day, is that being in compliance? Because he's not going to get it for a few more days. And the answer is yes, that's compliance. You got to mail it or personally deliver it within the 21 days. So I would try to get at least a proof of mailing to prove that you did it, because you don't want these tenants to claim you didn't do it. Well, let me tell you something. It's been 21 days and I didn't mail that itemization. You didn't? Nope. Didn't. Well, why didn't you? Notice how I do my own dialogue, Jeff. I didn't mail it because I asked that pesky tenant and he refused to give it to me. So I am absolved. I even asked him, I even have it on video, what's your forwarding address? And he callously refused, ladies and gentlemen. So therefore, what could I do? Well, the answer is you're going to lose this in small claims court faster than you can spit. And the reason is you had to mail it to his last known address. Well, what would that be? Well, that would be your apartment house or wherever he moved from. And hopefully he had a forwarding address. Okay. Well, that's what the law requires. If you know where he works, send it to his work. If you don't know where he works, then send it to the last known address. Now, if the envelope comes back, what do you do with it? And the answer is, don't open it. Keep it sealed. Sealed with that personal check for the next 5 years. Actually, it would be 4 years on a security deposit. 4 years for the statute of limitations. And don't open it up. Don't put a money order in there, by the way. Do a personal check. And when it comes back, don't open it up. And you know the only person who will open it up? Do you know who? And the answer is that pesky judge in small claims court. So bring when you get sued, bring the envelope with you and say, Your Honor, I haven't opened it up. It came back because there was no forwarding address, and feel free, Your Honor, to open it up. Let him open it up, okay? And this way you'll be absolved that you didn't comply with the statute by mailing it within 21 days. And again, we know what we're allowed to deduct for. And we know how we're going to fill out that itemization. Does anything have to go with that itemization? And the answer is maybe. If you are making deductions in excess of $125, then you have to have receipts or invoices showing what those deductions were for. So if you hire ABC Cleaning Service and they charge $325.62, and that's what you deducted for reasonable cleaning charges of the unit, then you've got to have that receipt with it. And that receipt better have their name, their address, and their phone number. And if it doesn't, then you have to supply their name, their address, and their phone number so that the tenant can call them and check, hey, did you really did Dennis Block ever hire you? And did he really pay the $342.62? And the answer is, yeah, he did. He's a nice guy, by the way. I use him for all my evictions, okay? So everybody uses me. So in any event, have the name, address. Now, let me ask you this. I'm not the kind of, I really am, but I'm not, for argument's sake, I'm not the kind of guy that's going to hire a cleaning service. And I'm kind of handy, I'm kind of a little bit of a contractor. I'm really not. So I would do all the fixing myself. So therefore, I'm not going to have a receipt. I'm going to do it myself, but hell knows that it took me 8 hours and I had to buy the smoke detector, which I put up myself, and I had to do all the cleaning, and I'm kind of really meticulous. I even got on my knees and cleaned out the oven and the stove and everything else. So am I allowed to deduct for that? Well, certainly you can deduct for anything you bought. So keep your receipts from Home Depot for that new kitchen sink that happened to be missing when you opened up the door. Or if you had to put in carpeting because it was really unusual wear and tear, keep your receipts from Home Depot or from the carpet place. But can I deduct for my labor? Or if I have a handyman and, I have him on call or he's on my salary, can I deduct for that? And the answer is yes. You have to include with it how many hours and what the reasonable rate of pay is, okay? So, and I want to do my own cleaning for these units because I like to charge $1,000 an hour. But I don't think that would fly. So you have to charge reasonable hourly rate. I don't know what that is, ladies and gentlemen. I think people at McDonald's get paid $25 an hour now. So at least $35. I think you guys are worth it. So, but what it actually costs you for your labor, if you have in-house persons or for yourself, pick a figure that's reasonable, and that has to be included with the with your itemization. Okay, so make sure that you do that. Again, if it's less than $125 or less, you don't have to include receipts. Now, what happens if I can't get this done in 21 days? I had to order parts and for the stove because, you took off all the knobs for some reason. I don't know. Maybe you considered them like Christmas decorations or something. I don't know. You were going to hang them on the tree and you took off all this and I can't find those knobs. So now I have to go out and I just couldn't get them in time, or I couldn't get a contractor quick enough to do this. So how do I do that? So in that situation, what you would be doing would be to give the tenant within 21 days, because you still have that time period. So in 21 days, you need to send them an estimate as to what it will cost, or maybe you have the contractor give you an estimate, or you furnish an estimate, and then you tell the tenant that it will be available shortly. And then you'll give him a final security deposit. So you're going to do the security deposit itemization. You're going to give him an estimate. And then once the actual invoices come in, then you have 2 weeks to send them that invoice with the final security deposit. So you're still going to do one security deposit itemization within the 21 days with your estimates. And then when you get the finals, and you should get the finals within 30 days, and then you've got 2 weeks thereafter to send them that with your final security deposit itemization. So make sure you do that, because if you don't, then technically you're entitled, you have to give him back his full security if you don't do it within 21 days. Even though there was a bunch of damage to the unit, you still have only 21 days to do it. Otherwise, you've got a duty bound, give it back to him. Can you sue him for the damage in a separate small claims court lawsuit, for example? And the answer is yes. but you still got to give them back the security deposit. Now, if you don't give them back the security deposit, could you file, if they sue you, could you file a defendant's claim for that stuff? And the answer is, I guess so, but I could just see some trouble going into small claims courts. So just bottom line, send that itemization within 21 days, have proof that you sent it and to the last known address or to where the tenant is, okay? And while we're on that subject, if there is money to return to them, I told you do it by a personal check. Don't do it by a money order or a cashier's check because it's going to get lost. But what if you have two tenants on your contract? How do you do that? How do you give the money back? Well, I'm tenant number one. You know, I was the one who gave you all the security deposits. Give it to tenant number two, right? You know, I gave it to you. You can even look and see that was my check. He didn't contribute anything, and I'm not really friends with him anymore. So please give me back the security deposit in full. And the answer, as you can figure, is no, don't do that. I don't care who gave the security. If there's two tenants on the rental agreement, they're each entitled to their prorated share. So make two separate checks out and mail it in two separate envelopes to those two people. Unless you know, like it's a husband and wife, then you can combine the check to Mr. and Mrs. Smith. But otherwise, if it's two separate people, then mail two checks. If you know where tenant two went, mail it to him. If you don't know where tenant one is, then mail it to him. You're going to do the same itemization, but you're one half to one and one half to the other. So make sure that you do that. What's another problem that people can get into? And that is you bought the building and during escrow, you got no security deposits. And then 5 years later, the tenant moves and says, where's my security deposit? And you say, what security deposit? I didn't get anything from the previous owner, and you were living here prior to me buying it. Well, you know what that pesky law says? That pesky law says that seller of the property and any successor in interest, that'd be you, are responsible for the security deposit. But hey, I didn't get it. Well, whether you got it or not, if the tenant can prove that he paid a security deposit, you are responsible as the, quote, successor in interest. Well, that doesn't seem fair. Well, let me tell you something. Nothing's fair when it comes to landlord-tenant laws, when it comes to income property owners. So don't ever use that argument because nothing's fair, as we all know. So when you buy a building, do your due diligence. Did you get a security deposit? If you can get the tenant to fill out an estoppel, on the estoppel that generally says what the security deposit is, take a look at the contract and see that it states, hey, you got a $2,000 security deposit. Technically, if the seller would have to certify, hey, I did get a $2,000 security deposit, but he broke all this stuff and we deducted it, and here's the language, here's the letter I sent, so he has no security deposit. I would follow up with the tenant on that prior to buying the building. That's called due diligence, so that you know that he really has no security deposit, because otherwise he walks in with his rental agreement saying $2,000 security deposit, you didn't send it, and any judge, as we know, in small claims court, you're going to lose. So make sure that you do your due diligence and that all those security deposits are transferred to you as the new purchaser of the building. Now, if you get this money transferred to you, or a new tenant comes in and gives you a $2,000 security deposit, we all know that we have to put that into a separate escrow account that you hold, a trust account, which holds all of those security deposits, and you can't touch them unless they're ready to be removed. And everything I just said was false, period. You don't have to put it into a trust account. You can go immediately. If the guy gives me a $2,000 security deposit, Jeff, can I go immediately, jump on the first Southwest plane, go straight to Vegas, and put it down on black? Can I do that, Jeff? Am I allowed to? Yes or no? Come on, give me an answer. I'm sure you're shaking your head no. Okay, I'll take that as a no. And the answer is, ladies and gentlemen, you can go to Vegas, you can buy a concert ticket, you can put it as a down payment on your car, you can do whatever the hell you want with it because there's no requirement of where it needs to sit. It could sit in your pocket or it can sit with your bookie, whatever you want to do. Okay, Jeff, by the way, give me your bookie's name after this. Okay, I've heard he's very nice. But when the tenant leaves, ladies and gentlemen, you got 21 days to account for it. Okay. So you had to put that money into an escrow account. No, I don't. In fact, I took your security deposit. I went right to Vegas and I tripled my money or I lost it all. Okay. So, but the bottom line is it sits there. Your obligation as a landlord, you know what you got to do within 21 days. You've got to account for it. That doesn't mean you give them the money back, but you got to account for it. And the only really problem would be COVID rent owed from from October of 2021 through January of 2023. He owes me that rent. I mean, I would feel sick having to give it back to him, even though technically, thank you, City Council, it's not due until February 1st, but technically you have to give it back. Okay. What if you forgot? I forgot. The guy moved. I'm a busy guy. You know, I'm running a law practice here. 21 days came and gone. I just forgot. I didn't even think about it. And then, ladies and gentlemen, you get a small claims court lawsuit. And it was a $2,000 security. So why am I being sued for $6,000? I don't get it. We haven't had the trial yet, but the paperwork says $6,000. I don't get it. I did forget. I'm sorry. You're right. I'm wrong. Why are you suing me for $6,000? Well, the code says that if it's a bad faith retention of the security deposit, and we'll go into what bad faith means, even though I really don't know what bad faith means. If it's a bad faith retention, then you can be liable up to 2 times the security deposit. So your security deposit plus 2 times the security deposit. So if the security deposit is $2,000, you can get a penalty of $4,000, total of $6,000 for bad faith retention. So what's bad faith retention? I don't know, but I'll tell you what I guess. Okay. I don't have all the answers here. It says bad faith. Do they give you a definition in the code? No. So it's whatever that small claims judge thinks is bad faith. So, hey, you know what? I forgot, but I paid on the 25th day. I don't think that's bad faith. You guys think it's bad faith? I forgot. 5 days. I was out of town. I gave as soon as I got back. But what if the tenant said, hey, it's been 21 days and you haven't paid it? And your response to the tenant, which is very reasonable, go screw yourself. Okay. And you didn't do it. All right. Okay. That's the kind of guy you are. You didn't like the guy anyway. Go screw yourself. Okay. So in that situation, I'm sorry, Jeff, but I'm on a roll here. Okay. That situation, I'm trying to give him an example here. Okay. That would probably be considered bad faith. Okay. You were even warned, hey, where's my security? And you didn't even step up to the plate then and send it out. And I don't like your language. So in that situation, by the way, the things I say have nothing to do with the AOA. Okay, I'll give you that admonishment. It's only Dennis Block. Okay, has nothing to do with Jeff and the AOA. They're very, very proper, by the way. But in any event, that might see. I gave you the admonishment, Jeff. In that situation, that would be considered bad faith, and you would be responsible for technically up to 2 times. So, bottom line, just do what you're supposed to do with the security deposit. Now, I just went through Civil Code section 1950.5. You can look it up. You can read it yourself. I read it myself this morning at about 8 o'clock when I got ready for this thing. And so if we want to open it up to questions now, I am ready.
All right, great. You make me laugh, man. Definitely. You're the comedian attorney or attorney comedian. I don't know which one goes first. So thank you. No, really, it's thorough and also fun to track with for sure. So if you guys have questions, definitely go ahead and put them in the chat and we'll get to them. And like first one here. And then I just want to say, just because this is a time oriented thing, there's the ERAP program. If you're in the city of LA, that ERAP program opened back up for a little bit. We sent an email out that had that information in there, but I believe it closes on Monday. Is that right, Dennis?
Yes, ERAP deals with that tenants can apply for additional compensation, more of a money grab, so that they can pay their landlord's rent due to,
Right.
quote, the pandemic, so that they don't get evicted. I don't know how much money is being given, but there is a time period on it, yes.
Right. And that's only specific to people who can prove they had a COVID hardship and are also 80% of area median income. So,
Well, then that would mean that nobody will be eligible for it, right?
right. So we'll see how many, but anyway, if you have a tenant that's in that situation, here's that one last final notice for you. And on YouTube, we have Grandma of 3. Can we get his slides? Basically, you shared a couple Word documents there. Should they email you, or how should they get that?
Actually, you can, this is going to be on YouTube. It's going to be on for forever. So when you get to that screen, just freeze it and then just take a picture with your camera. It'll be on it.
There you go. And then also, I did want to mention, it's kind of a good time to mention it, but we do have Form 133. That is the form where you can just document returning the security deposit. It's a letter for them. So that's one thing that we have. If you're an AOA member, you can log in and get that one if you ever need it, or you will need it for sure. So hope you're using it. If you didn't know it existed, now you know. All right, Amanda on YouTube. Can a landlord deduct painting and cleaning expenses upon move out? They wrote this question before you covered it. So I am assuming that has been answered sufficiently in the chat. They're watching AOA US on AOAUSA.com. It's Shirley. LA County Rent Control unincorporated. What does the ordinance require? A 10-day or 3-day notice to cure violations?
In the LA County, you have, let me look that up real quick. I think it's 3, plus you have to send something. Actually, for a notice to perform or quit, I do know it's a 10-day notice. Let me pull it up here. It's a 10-day notice for the notice to perform or quit, and you have to mail a copy of the notice and the proof of service within 5 days of the service of the notice.
All right, Lynette on YouTube, this is a good question. My tenant allowed water to damage my home, causing over $20K in repairs. Insurance paid the claim, but can I deduct expenses related to this from the security deposit?
You broke up a little bit, Jeff, but I understand that there was water damage. Obviously, if there's water damage which was caused by the tenant, maybe they let the sink overflow, then of course that would be considered unusual wear and tear, and you would be able to deduct for it.
Okay. There we go. Next one, Hermosa property, the city of LA. Tenant moved out after COVID restrictions were lifted, owing $60K in back rent. No forwarding address, and all mail was returned. How can we serve him, and how can we proceed to collect? Oh, they didn't watch the video from last time about how to collect on debts that you did, huh?
I guess not.
But you can still answer. Yeah.
Well, I mean, if you're going to, first of all, in small claims court, the jurisdictional limit has been raised to unlimited for COVID debt. So you can sue them for that. But the issue is, if you go down to small claims court, which is the most efficient way to do it, and then you file your paperwork, they're going to give you a case number. They're going to give you a date of the small claims court hearing. But the next thing you have to do is you have to serve them. So how are you going to serve them if you don't know where they are? Well, if you know where they work, you can always serve them where they work. If you don't know where they work, then you can hire a skip tracer. I know for my clients, once the tenant leaves, if they establish credit someplace else, we can generally find where they're moving to allow you to serve them. Usually we have to wait like 6 months for them to establish credit at a new place. So don't file your if you're any of my clients, don't file your small claims court, or if you want us to do the judgment for you, don't file your small claims court until at least 6 months. Then we can then see if we can locate them.
Right. And you guys do have a collection service.
We do.
Yep.
And we do a ton of collections on a monthly basis.
Right. Okay. Nazila on YouTube. How many people can live in a 225 square foot in a RSO building in Los Angeles?
Okay, well, there's two issues that we're talking about when you raise something like that. And the first issue is how many people do I have to allow to live in my unit? It's only 225 square feet. And the answer to that is fair housing, which I like to call unfair housing, has a rule of thumb, which is 2 per bedroom plus 1. So if it's a 1 bedroom, that would be a total of 3. If it's a 2 bedroom, that would be a total of 5. And what if it's a single? If it's a single, you can't just limit it to 1 person. Do you know why? And the answer is because you'd be discriminating. Why would I be discriminating? I'm renting it to 1 person. I don't care what color they are, anything. And the answer to that, or color or race, the answer to that is then you're discriminating on the basis of children. Because if you only allow 1 person in, if a mother's moving in with her child, and therefore a child could never rent your unit by himself or herself. So on that basis, you have to allow at least 2 people for a single. Okay, so that's half the question, which I don't even think was possibly what the issue is how many people can I allow to move into a 225 square foot apartment? Well, you got the rule of thumb. But you see, I have no rental agreement because I bought this building. And God knows there's 7 people in a 225 square foot apartment. Do I have to allow that? What if there's 10? And the answer is that it's very difficult to evict for that situation. There is some California law that I looked up a long time ago that said how many people based on cubic feet. Nobody enforces it. You wouldn't be able to evict for that situation unless you can get the city or the municipality or the county to come down and cite you for overcrowding. If they do, then I have a good case for eviction. But otherwise, it's almost an impossible case. Now, obviously, if you have a rental agreement, the rental agreement is going to state who can live there. And if they got 10 people in this single, then we could easily do an eviction. But so the problem crops up, and probably what the chat person is talking about is that, hey, I got this building, I don't got a rental agreement, they just keep moving more people in. How do I do it? How do I get rid of them? I don't think you can really get rid of them on that basis alone, unless you get some sort of a citation from the city. You might be able to get them for a nuisance if they're making a bunch of noise or that type of thing.
All right, there we go. Here's Cheryl. Can you please talk about paying interest on a security deposit?
You know, I meant to talk about that and forgot. Los Angeles has, not every place, but I know Los Angeles has interest on security deposits. I thought about this last week and it never came up. So you have to still give interest on security deposits. The interest is incredibly low. If the person's been there for 10 years, and the security deposit was, I was trying to figure this out, and the security deposit was $2,000, and you're supposed to pay it yearly, by the way, in the city of Los Angeles. For 10 years, I did the addition on 2,000, and you add it up each year. It's even less than 1% now. It's 0.002. It's less than $10. So if you never gave the security back for residential RSO properties for the city of Los Angeles, and just give them an extra $20 or 15, depending, because I know $2,000 was less than $10. So be on the safe side, give them an extra $10. It amounts to nothing. And just make sure that you add that to the security deposit for properties in the city of Los Angeles. So, right, I got a $2,000 security deposit, interest on security, give them a little bit more, be generous, $20, and now deduct the $4,000 that they owe you in rent. So you're not giving them back any money anyway. But that's a good question.
Right. So depending on the municipality, that may or may not come into play.
Absolutely. And you can do a Google search, which is what I did over the weekend, and do Los Angeles interest on security deposits. You'll see the rate sheet going back 30 years, and you'll see it was basically nothing. I think there was 1 year, like 30 years ago, that was 3 or 4%, but most of the time it's less than 1%.
Great. What do you do if you didn't, if you're supposed to be paying that annually and you're not? What are you supposed to do? How are
Just
you
give it
supposed
to them give it to them at the end.
Got it. Okay. Juanita on YouTube. Can I collect a non-refundable pet fee of $500?
Can you collect? Would that mean you're the tenant?
No. Yeah. So they're from the,
Okay.
obviously from the
So
tenant.
the
Yeah.
answer is, if you're the landlord, the answer is no. There are no such thing as non-refundable deposits. As I mentioned at the beginning, it's only a security deposit. It's not a pet deposit. It's not a last month's rent deposit. It's not a refrigerator. It's a security deposit. You can get up to 2 months rent for an unfurnished unit.
What about an administration fee on the front end or some? Is there any fee that you can charge besides the
An administrative fee, that's an interesting question. I would probably caution against taking an administrative fee, because they'll talk an administrative fee, like you say, well, this is the charge we're doing for initial preparation of renting out the unit and the cost and accounting of going through everything. I wouldn't do that. But you can have, which I meant to talk about, you can have an additional fee if you and if you have to put this right into the contract, that, I love this unit, but I'd like you to put in a new chandelier because that one looks a little cheap to me. And, I'd like the cabinets painted a different color. They're green now, and, green's a little outdated. I like them. You can then charge the tenant a fee for that, put it in, because he wants it to be either altered or redecorated. And that's a permissible charge that you can ask for in your rental agreement. And it's not in violation of the security deposit.
All right, there you go. 470 rent. Can I charge an increased deposit not to exceed the total of 2-month deposit if they have a pet that I don't collect? If they don't have a pet, oh wait, this is pretty confusing how this is.
Well, let me just tell you a little
Yeah.
bit about this. In the city of Los Angeles, you are entitled to increase the security deposit for RSO properties to the same rate that the increase is. So they're talking about, come February 1st, after 4 years, they didn't let us have a rent increase. And by the way, was there something called inflation in the last 4 years? We're having a little inflation. And what does it cost now to get a plumber to your building? But for the last 4 years, you weren't entitled to a rent increase. So they're talking about, come February 1st, they were entitled to a whopping 7% rent increase. Technically, you can increase the rent. This is for RSO properties subject to the rent stabilization ordinance, 7% as well. So whatever the rent increase is, you're allowed to do a similar rent increase for the security deposit.
There you go. You can increase the deposit. There it is. All right. And I wonder I wonder if that's true in every municipality.
I presume
Hard
if
to
they, depending on what their rules are for that.
Yeah, so you may want to check that if you're watching in Berkeley today. So, Jimmy, can we make a Section 8 tenant pay the full amount of rent after the new ownership of the property, because housing authority might take 1 to 2 months to pay the new landlord?
No, if you're buying a property and you have a Section 8 tenant, you're stuck with waiting for the Section 8 to pay their share. And of course, once you become the owner, you obviously have to give notice to the tenant that you're the new owner with all those requirements, but then the tenant has to pay you his share.
There we go. All right, Hendrik on YouTube. Let's say someone is low income. They want to move in but can't afford the security deposit. Could it be woven into monthly rental payments?
And the answer is yes. You're out of your mind to do this, but yes, you can make it where the security deposit is paid in installments. And if the tenant misses an installment, that would be a good case for eviction. So as long as the total security is in accordance with the law for an unfurnished unit, let's say 2 months rent. So let's say you have $1,000 rental and you're going to get a $2,000 security deposit. And then he's going to pay you $500 a month for 4 months. That certainly is legal. The reason why you don't want to do that is because as soon as that first time period becomes, you're going to be getting on the phone and calling 1-800-77-EVICT because the guy will never pay you even the rent or the security deposit. It'll never happen. And with all due respect to Jeff and the AOA, you don't need to do a credit check because if the guy doesn't have the full security, that's the best
right
on the planet. Don't rent to them. Don't waste your money for the credit check. Don't waste your money calling that 1-800-77-EVICT number because you know you're going to be doing an eviction. Just don't do it.
Right. And that's you're basically, you have criteria. You're screening this person out. If they don't have money management skills to have it, then, and that's another reason, like there are those things where you can pay, they can like buy a what is it, like lease protection, and they're paying like $20 a month or something. Those products are out there, but even my dad is like, I don't believe in those things, is what he told me. And I'm like, okay, yeah, I kind of see your point. Because if they don't have a little bit of a cushion coming into it, they don't have any cushion for when the transmission breaks or when anything else happens. And so just avoid it. That's thin ice, right? Okay, Jerry in LA County in Lancaster. Can a landlord or property manager request the application and fees before allowing the applicant to view the property?
You can charge for an application process. I think it's up to, you probably know better than me, $45, I think. And you can charge that, but charge it before. I mean, you can charge for an application process. I guess you could do that if the tenant wants to do that. I mean, I know if I was an applicant for a unit, I'd say, let me see the unit before I start giving you some money to see if I even want the unit. So, but I guess legally you could do that.
Yeah, but if usually part of it's the rental is the credit report is paying for that part. They could request maybe the service fee part of it, right? Like them going to the cost that they're incurring on that. Interesting. And that could work, I guess. But okay, Francisco, can you deduct from the deposit any unpaid late fees and return bad check fees?
Well, technically, assuming you have the right to charge a legal late fee, you have the proper language in your contract, then the issue is, can you deduct it? And the answer is probably not, because you're only allowed to deduct, and I already told you, for rent, unusual wear and tear, and damage. So is that rent? And the answer is late charges is not rent, it's late charges. Now, can you have a phrase in your contract that says all monetary obligations are to be considered rent? And the answer is yes, you could. And if you had that, then that late charge is rent, and then I don't have a problem you deducting it from the security deposit, assuming you have the correct late charge deposit language or late charge language in your rental agreement.
All right. And what proof of late rent is required? He said, she said?
Well, I mean,
not that, is it?
You can't prove a negative. So, hey, you paid me the rent, but you paid it on the 10th day. Well, here's your check, or here's when it went into my bank account. So when you got the funds should be easily proven by the landlord. All
right, there we go. Okay, Michael, but how do you deduct $6,000 in lost rent from a $1,000 deposit? Are you saying we should go after them in small claims court?
Well, it's very simple to deduct. It's just math. It works out to be a negative $5,000, which is the balance owed to you. And of course, you can go sue them in small claims court, assuming it's due at this point. Okay, and here's one. After 8 years, the new carpet had 2 dogs specified in the lease, which they replaced with a bunny, dogs, and cats. In fact, they ran a grooming business. Turns out urine is behind the walls, so we had to rip out. Is this normal wear and tear? And obviously,
It's not normal wear and tear,
Well, I
even if
think
it's 8 years, is it?
the walls that had to be removed because of the urine, that I think is unusual wear and tear.
Yeah.
But doesn't a carpet have to be replaced after 8 years in most situations? Can you really still use it? Hey, my experience is I use carpets for 15 years. It's a great carpet. So in that case, the answer is yes. But it's what's your normal practices for that type of carpet? Does it
Mhm.
really need to be replaced? I think in most situations it probably need to be replaced anyway.
Right.
And go
Depends
with
on that.
those synthetic
Did-
hardwood floors. They're much better.
Right. Cheap carpet, you're gonna end up replacing it, right?
Yep.
Samuel, if there is a commission paid to the leasing agent for renting a unit, is that passed on to the tenant who is leaving the unit before the end of their lease term?
I'm sorry. What was that? One more time?
So what if there's a commission paid to the leasing agent for renting the unit? Is that, they didn't say fee, but is that fee passed on to the tenant who is leaving the unit
Okay,
before
now I
the,
get it. The
yeah,
answer is no. The commission has nothing to do with the tenant. The tenant is responsible for rent to the end of the lease term. Okay. You have to use your best efforts to re-rent it to somebody else. To the extent that it's not re-rented, then you can deduct that from the tenant security. Now, what if, and maybe this is where the question was going, what if you had to hire an agent and paid a commission to an agent to lease it out? And let's pretend the agent charged $2,000, but I did get it rented out on October 1st. You are allowed to deduct the agent's commission because that was the cost, including any advertising costs or any other costs associated with you using your best efforts to lease it to somebody else.
there we go. That's good. All right. Can we Zelle, Venmo, etc. for a refund of the security deposit? Does it
You
matter?
certainly,
Payment method, does it matter?
as long as the tenant agrees to it. Otherwise, you need to mail a check.
All right. Irma on YouTube. LA County property under AB 1482. Can we serve a 60-day notice for a family move or substantial renovation outright now?
Well, it's not part of what our speech is today, but the
Yeah, it's a
answer
little-
is yes. Either one, if you're just under AB 1482, you can do a substantial remodel, or you can have a family member move in. You have to pay relocation. Relocation is a whopping 1 month's rent. For family member move-ins, they have to be close family move-ins, like grandparents, parents, yourself, your spouse, your children, and your grandchildren. For renovation evictions, it has to be work that the premise is going to be uninhabitable for at least 30 days and requires the obtaining of a building permit, like an electrical or a plumbing permit.
And speaking of renovation evictions, we have SB 567 that's on the desk of Gavin Newsom. And that will, I think it, oh gosh, all of a sudden my mind's blanking, but I believe that it adds to that. Tenants are protected from day one. And I believe that the renovation eviction, it makes it much more, it's like 3 months of relocation.
Yeah, the renovation grounds that were in AB 1482 was basically a savior for landlords who needed to get back their place. So I'm not aware that that law has passed yet. I'll give you an opinion on it once I see the completed copy of it. But right now, if you can do a renovation eviction, oh my God, let's do a renovation eviction right now. If you're in areas that you're subject to AB 1482 statewide rent control. We're going to do a couple more, Jeff.
Yeah.
And I'm going to get to the phones. My
Great.
phone.
Yeah. There's just so many questions and we appreciate all of them. And we know that you have them. And you're going to have to call that 800-77-EVICT phone number and get an answer from Dennis. So good luck, Dennis. But all right. So S. White on YouTube. If a tenant moves out in the middle of the lease, I am obligated to advertise at the same rent as per the tenant lease agreement. And so of course not.
No, of course
Yeah,
not.
of course not. So yeah, get market rate rent, rentometer.com and look at, yeah, just comp it out. All right, let's take another one. Real estate prof. Can we require, in air quotes, tenant to use a licensed contractor for necessary repairs prior to move out if tenant elected for pre-move out walkthrough?
It's a good question. The code is silent on that issue. However, if the work requires a licensed contractor, then the tenant would be duty bound to have that.
Right. I mean, just thinking in the case of lead-based paint, there's some things that if they're fixing it, really, they do need that. And then also you have your insurance policy. And if they're not using someone, just check your insurance policy to see if it would void the policy if something were to happen with an unlicensed contractor. But
one more thing I would like to state, if you guys have any questions, and I hope Jeff doesn't mind, I am doing a Zoom every Saturday at 3:00 in the afternoon. Go to my website, evict123.com, and you can just tune in, and we're just going to no specific topic. But if you got questions, including the people who didn't get here, tune in 3 p.m. on Saturday. And Jeff says he's going to be a co-host with me. We'll wait and see on that. But it'll be me. You'll get to see the interior of my home office. And so tune in. Just go to the website once again, evict123.com. And we had some technical difficulties last week. It was pretty bad, but I think I've got the kinks worked out now. So tune on in. Thank you.
And also they can catch you at the trade show. You'll be there all day.
Oh, absolutely.
And you'll have some of your staff with you for sure. So come out to the trade show and get them in person and see them in person. And there's a whole lot of other stuff there. So, hey, Dennis, I appreciate your time, and everybody, thank you for tuning in. And yeah, just trying to be compliant. It takes some effort. So here we are.
Thank you very much, Jeff. You have a good day.
Okay, take care, everyone.